All right, so Major Matt Neal, thanks for joining us today. Major Neal, let's see, ADC at Minot, right? And then a long and stellar career at JAJG.
That's right, sir.
STC, the Special Victims STC. I think I designated you as Special
Yes, sir.
Victims STC. And a little bit different than some folks. You came back to JAJG, did appellate work for some time, and now you're also out as a Chief Regional Senior Support Senior Trial Counsel.
Yes, sir.
We'll call you King of the
King of the Central.
King of the Central, fantastic. And again, like other STCs we've talked to, very successful. Don't let that go to your head, but you're very successful. Do you think that the appellate experience you had, I'm sure it has helped you as a litigator?
Absolutely, sir. I believe it has. I've always been a scholar of the law. I've always loved to read cases, even before I was in the appellate shop. One of my nerdy aspects that I have. One thing I loved about law school is reading cases. And then being in the appellate shop, it gave me a different perspective. Not just reading cases, but also advocating for those cases and identifying really what the appellate shop was always screaming about when I was trying cases in court about protecting the record and things that are important on appeal. And it gave me that perspective to be able to protect the record coming back into the trial court again now.
So young counsel out there that don't have a chance to be at the appellate government, what can they do to sort of gain that same experience?
They can ultimately, a couple of things. One is they can talk with counsel that are at the appellate shop and get that experience from them. The individuals at JAJG, I know that from my time up there at the appellate shop, we live vicariously through the trial counsel out in the field.
As SJAs do as well?
Yes, sir. So call up, talk to them about your cases. They love to do that. They love to answer questions, and they love to identify those concerns that they might have when a record comes up to them. The other big thing that I would have, and probably the number one piece of advice for junior counsel out there, is read.
Okay.
Read cases. Go to the Court of Appeals for the Armed Forces website, go to each of the service courts websites, and read the cases that come out. Know the law, because that's the most important thing I think you can do going into a court martial.
Okay. Well, that nerdy stuff is great, but I know you're a fantastic litigator, world-renowned litigator. And you work some really big cases, the crime murder case out there, a couple other cases like that. Tell us why you love litigation.
Sir, I've always been, my entire life, I've been an athlete. I've loved competition. That's one of the things I strive for in life. It is competition. It's one of the things that keeps me going. It lights my fire, keeps my engine going. And for me, litigation is the closest thing that I come to in competition, to sports, as an attorney. And so when a judge comes in and sits down and calls the court to order, that's like the referee blowing the whistle and starting that competition. And then it is an adversarial process. Certainly, it's a truth-finding process, but it's adversarial. Both sides are advocating for a position, and we're advocating to either a judge or a panel of members. And to me, it's that exhilarating experience that's why I love litigation so much and keep coming back to it.
And so, obviously, you got the appellate background, the love of the law, but are there other aspects, sort of tactically, that make you successful as a litigator?
Yes, sir. What I've always been good at, what I pride myself on, is a complex or a complete understanding of the rules. The rules of evidence and the rules that ultimately apply and the law that applies in a court martial. And that allows me to ultimately kind of control the battlefield in a court and understand exactly what evidence comes in, why it comes in, and then what evidence doesn't come in and why it doesn't come in before the members, and be able to control that battlefield. I think that's what's assisted me in being such a good litigator over the course of the number of years I've been doing it, is that understanding of the rules.
All right. And so, without having to name names, what do you see that litigators, maybe young litigators or experienced litigators, have the most trouble with that undermines their ability to really be good at their job?
It's kind of a piggyback on that same answer that I just gave about the rules. It's been somewhat astonishing to me to see some of the lack of understanding of the rules at times in courts martial, particularly with regard to cross-examinations, a lack of understanding of prior inconsistent statements or refreshing recollection, and attorneys not knowing how to lay the proper foundation for that. And that gets them hung up in front of the members. And when they're up there doing that and they can't lay the proper foundation and they keep having objections sustained to that, it undercuts their credibility in court significantly. And it shows, one side does understand the rules, and then the other side potentially does not. And that was the same experience I had as a defense attorney as well, as a defense counsel. The trial counsel not understanding those same rules for prior consistent or inconsistent statements and refreshing recollection, things like that.
Okay, great. So you got a bit of reputation out there too. You're certainly a bulldog, well-deserved, I think. I think that's a good moniker, because I think you're also considered a civil guy who can work with all parties to the case. Obviously, that's important in the JAG world, particularly, we go back and forth, which is generally your, I think, sort of perception from the judge and the members as well. But how do you deal when you're an aggressive person, maintaining that level of civility in court?
It's difficult because, as I said, I'm an athlete. It's a competition, so everyone wants to win. But that can also be a bad thing, and that's one of the things that I think sometimes counsel lose sight of. They take things personally. They ultimately come into court and they're trying to win, and they look at winning above everything else, winning at all costs. And that can be a detractor. That can be a significant negative because you lose sight of the big picture. You lose sight of what the purpose of the court martial is, and that's doing justice. And yes, I'm going to go into court. I think one of my OPRs even called me a bulldog that a military judge had called.
I see them.
And yes, sir. And I go into court. I'm passionate. I'm aggressive in court. I'm probably one of the more aggressive attorneys that you'll see on the record. However, when the court is adjourned, when recess, you have to be able to work with the other side. And you have to be able to leave that in the courtroom, anything that may have happened there. And you have to understand what, one, the big picture is, and two, what the other side of that picture is. Sometimes if you get too aggressive about something, or you have to keep it in check because you can only see one side. It puts blinders on. And you have to be able to maintain that big picture look and not put those blinders on in advocating position. And I think the biggest part for me is understanding that. If you understand that, you can make sure that doesn't happen. And that's how you maintain that civility, I think.
So is it, we have different personalities in the court.
Yes,
so
sir.
is it tough for you to work with maybe young counsel who's clearly doesn't have the confidence that you've got and the experience, and they're not as aggressive? How's that dynamic? How do you work that dynamic?
Actually, I think that dynamic is not actually as troubling as you would think to work. In fact, I think it's tougher for me to work with someone who is as aggressive as I am. For instance, right now I'm working a big case with a colleague of mine. Certainly not lacking for experience on my side. In fact, I think he's more experienced than me, as much to my chagrin. But he doesn't have the same tactic as I do. I think our tactics play off each other very well. I've learned a lot from him, and honestly, he's one of the best litigators that I know. I'd be hard-pressed to name anybody that I could identify as a better litigator than him. And certainly he's doesn't have that same aggressive personality. But what everyone has to remember, and something that I've always understood, and what I tell junior counsel is everybody has to pick what works for them. Being an aggressive, being the bulldog, as I've been identified, works for me. It doesn't work for everybody. Some people have to be the more reasonable. Some people do the bubbling idiot routine in court. That works for them. Intentionally or not intentionally, and it works for them in court. But everyone has to find what works for them. And I actually think one of the things that my aggressive personality and my confidence in court does for those more junior, inexperienced counsel, while they don't necessarily have to be as aggressive as I do, what they can do is gain some of that confidence that I have. And I think it helps them in that aspect, and I try to pass that on to them. That's the biggest thing, is building up their confidence. Not necessarily making them aggressive, just building up that confidence for them.
Oh, excellent. So when you do deal with new trial counsel, do you have a sort of a general approach to getting them involved in the case or getting them past problems that you see young counsel dealing with in every trial?
I do. My approach is to, first off, I like to be detailed to a case as early as possible. Sometimes that doesn't work.
Sure.
In our world, as you know, sir, it doesn't always work for us to be detailed at the ground floor. If I'm detailed at the ground floor, I'd like to get them involved very early on in discussions with me on that. And one of the big reasons for that is because they have other things taking their attention away. They've got other responsibilities they have. But I want to try to impress upon them how important this case is. I want to get them involved in trial strategy decisions. One thing I always tell every junior counsel, which I think lets them feel that ownership part of the case, lets them feel invested in the case, is that, hey, this is a team. And I want your input on opinions. I want your input on trial decisions. Ultimately, as the lead counsel, I'm going to make those decisions in the end, but your input matters. And I want to show them that input matters. And so I don't like to make decisions without going to that junior counsel and asking them what they think. One is a sounding board to know if I'm sounding crazy, sometimes it happens. And two, so that they feel like their input ultimately does matter. Because to me it does. I learn by talking things out with people and for my own trial strategy decisions. I make decisions by talking them out. So it's helpful for me, but it's also helpful for them because they feel like they're part of that process. I think one of the things that some junior STCs do that's probably not so great, and it's just to learn this tactic, is they go in there, their lead counsel, and they just make the decisions. And they do it without consulting their junior counsel, their assistant trial counsel. And then that assistant trial counsel just feels like they're a potted plant, or they're just the admin guy, or the admin girl for the case. And so they don't feel like they're part of the team, part of the case. And I think it's important to make sure early on that they feel invested in it.
Okay, great. So we'll drill down on particular aspects of the case in a minute, but let's talk real tactically about what young trial counsel can do in the well better, whether it's movement or tone or inflection. What are they sort of lacking that they should focus on? Big picture.
Big picture, they should focus on a couple of things. It's not the list that you just identified, but knowing the rules that govern what you do in the well. That is, I think, to me, even more than half the battle. You know the rules and know what rules are going to come into play, and you are going to gain that confidence in the well. It's going to transfer to what you're doing in the courtroom. You're going to understand it, and you're going to be able to then control the battlefield. For me, the biggest part in the courtroom is that confidence. Perception is everything. And even if you don't necessarily feel like you know what you're doing, you might not know it, if you look like you know what you're doing, the members are going to believe you know what you're doing. And so knowing the rules, I think, is more than half the battle to getting yourself there. And then beyond that, it's always moving and doing everything with a purpose.
Yeah.
Why? Ask yourself that question, why? Why am I asking this question? Why am I moving this way? Why am I standing over here? Those are all questions I ask myself beforehand. Where am I going to stand when I do a cross-examination? Where am I going to stand when I do a direct? How am I going to move when I do a closing argument? Because those things are the things that the members pick up on. And those are the things that I would that I don't think junior counsel are thinking about. They're not asking the question of why. Why am I doing this? What is my purpose for what I'm doing? And if you answer that question and you have a purpose in mind, it's going to pay dividends down the road.
Right. So a little off that topic, but it raises another issue. How should young counsel work with witnesses to get them ready to be in the courtroom, to be subject to a direct and be subject to cross-examination and everything that's associated with being in court?
Yes, sir. The way I do it with witnesses go in, I think this is a good tactic to have, and I think, frankly, every junior counsel should be doing that. First off, you should be talking to the witnesses frequently, particularly when we're talking about victims in the case. That doesn't mean you have to ask them substantive questions about everything that happened or interview them over and over, but you need to make sure you're keeping in touch with them, to keep that rapport going, to make sure that they understand what's going on, and answer any questions they have, because that's going to make them feel much more comfortable. And then I bring every witness into the courtroom. I think they should be shown the courtroom. I think they should sit in the witness chair. And I think they should understand how to answer questions from that witness stand. I tell them exactly where I'm going to stand when I ask questions, and I also tell them where I think defense counsel will stand. Because that's how I did it when I was a defense counsel, and why defense counsel might stand there, so that they understand that coming in. I also explain to them that while defense counsel, they're doing their job for their client, their job is to try to get a rise out of that witness. So I want to make sure that they're ready for that, and they understand the types of questions they're going to get, and the types of ways those questions will be asked, and what the purpose of asking those questions is. So they understand that, so they're ready for it when the other side asks the questions. I also make sure that every witness understands that even though the other side is going to be able to ask cross-examination questions, we always get to get back up and have them explain everything. And so making them understand that process and having them see the courtroom, because I've testified as a witness in a trial before, as a senior trial counsel, I had to testify in the case, and it was nerve-wracking.
Yep.
It was nervous. I mean, you remember it, sir. It was throughout, midway through the trial, there was a 39A, and I thought to myself, how did I get to this point? Because it is such a nervous experience for me, and that wasn't even anything substantive necessarily about the case.
Right.
So understanding that, and that's how every witness feels coming into a court. It's not a pleasant experience, and making it as comfortable for them as possible is the most important thing.
Yeah, great. So I know this isn't about me, probably should be about me, but I asked the question because I note that too when I was out in my good old days as the chief, go out and do cases. Trial counsel always wanted to meet with the witnesses in the library or in their office, and it's my practice, even if I'm just sitting around talking to a witness, we always do it in the courtroom. We'll pull out some chairs and talk, and then we'll get in the witness stand, and we'll kind of talk that way as well. So I think it's a great tip for trial counsel.
Yes, sir. That's the way I like to do it as well. Bring them into the courtroom so they can see where it's going to be. They're comfortable with the room.
Well, we're both doing it. It's got to be the standard.
It's got to be right, right, sir?
Okay. All right, let's talk specifically then about some things people do well or they could do better in various aspects of trial practice. So let's start. Let's talk about voir dire.
Voir dire, the biggest thing is thinking about the questions that you're asking, tailoring your voir dire to the case that you're actually trying.
Yeah.
Too many times people use canned voir dire. A quick example that I'll use, and this was from an STC, I won't name any names, called me up and said, hey, I've got this BAH voir dire that you did for a case. They had pulled off of a SharePoint. And I was wondering, I'm going to ask these questions about Goldilocks and the Three Bears, but I was wondering why you asked those questions.
I remember that.
And I said, where'd you get that voir dire from? Because I don't remember ever asking those questions. It turns out an instructor from the JAG school had pulled it down to do it for one of the cases they were doing. They had changed some questions. And then had unknowingly edited the document on the SharePoint. But someone had pulled it down and said, okay, I'm going to use this can of beer, and they're going to ask about Goldilocks and the Three Bears. So think about the questions that you're asking. And with voir dire, you want to, the main thing for me, the biggest thing for me is not to lose credibility with the members. You want to connect with them and not lose credibility. It's your first experience, your first time to talk with them, and you don't want to lose credibility with them. So make sure you're asking questions that actually have a purpose and questions that are simple, not lawyer questions.
Yeah, so avid listeners or watchers of this program know that I hate voir dire.
Yes, sir.
And it's always my advice to trial counsel that you should follow the doctors, the Hippocratic Oath, and first do no harm.
Yes, sir.
That is no more true for trial counsel than in voir dire. That's your one opportunity to completely lose all credibility with the members.
Yes, sir. My advice, certainly from the government side, is always the biggest thing you want to avoid is putting your foot in your mouth in front of the members and losing that credibility. And if you do that, you can count that as a win in voir dire.
Absolutely. All right, how about opening statement?
Opening statement, you want to tell a concise yet compelling story. And you want to make it a story, not just a rote recitation of the facts that they're going to hear. Oftentimes, when I get the initial opening statement of the case or their initial drafting, the evidence is going to show this. This witness is going to say this. I don't like that. I like it to be a story about the facts, a very concise story. It shouldn't be too long. A concise story and compelling story. And the biggest thing for me is not to oversell your case. Because the one thing I like to take from opening statement when I stand up in closing argument is I like to be able to say, members, think back to opening statement. We kept every promise we made to you. And I want to be able to say that in every single case. And that's what the biggest advice I can give for opening statements. Short or concise, compelling story that doesn't oversell a case.
So I don't know where they're learning this, but I often saw theme and theory sort of jam down the throat of members during opening statements. What are your sort of thoughts on, I think theme and theory is important, and I like to carry a theme and theory from the start to the finish, and one that works from the start to the finish. But how do you get that across the members without hammering it too hard?
Well, it's will come probably as no surprise to you, sir. I'm not a big cutesy theme and theory guy.
Yes.
I don't like that for a couple of reasons. I think one, members get the repetition. I think they just get tired of hearing that, and it's forced, and it can be turned around against you. These cutesy theme and theories. For an opening statement, you begin with it and you end with it, and as long as your opening statement isn't too long, that's enough in the opening statement. But you want it to be a central fact of your case. I use as a theme and theory. A quote, a sensory details about an issue, kind of things that really can resonate with the members. Things that ultimately are going to be the central aspect of your case, as opposed to trying to come up with a contrived theme and theory. You want to come up with a short, concise fact of your case that really summarizes everything, and use that as your theme and theory. And then it's not going to become so much as a forced theme and theory that we're trying to hammer down everyone's head. I think that is something that they are being trained out there. I'm seeing that as well. Somewhere they're coming up with this idea that you have to come up with a theme and theory for every case, contrived, and you have to then say it over and over in an opening statement. I'm not a big fan of that either.
That's great advice. Direct's easy sometimes, but it can throw a case if you don't do it well. What are your thoughts about how, particularly young trial counsel, since they're doing a lot of the directs, can do that better?
They can, first off, the directs, I think, part of the myth is that directs are easy, and that can, because directs can derail your case. Witnesses, because you're asking open-ended questions, sometimes crosses are easier, because you're asking yes or no questions. In directs, you're asking open-ended questions. The biggest thing that trial counsel I see as a failure is they don't listen to the witnesses' answers. They've got their questions written out, which I'm never telling them don't write questions. I think everyone has to do it in their own proper way. But listen to your witnesses' answers. Because a lot of times they answer that next question. And then they ask it again. And the members, you can see the quizzical looks on the members when the question is asked and the witness just answered. And it's because counsel wasn't listening to what their witness said. That's the biggest advice I can give for junior counsels. Listen to your witnesses and then use those answers. Loop them in as you're asking the next questions.
Yeah, so cross-examination, you're right. That can be easier because you're in control at that point. So give me some thoughts on that.
Yes, sir. It can be easier, but I see it done poorly is when counsel get up and they give this long cross-examination that simply restates the direct. When I do a cross-examination, you will hardly ever hear me ask a question that was asked on direct, unless I'm confirming the answer so I can then impeach them. You should not be just reiterating the direct of the witness. When I was a defense counsel, if there wasn't an STC on the case, I would call my client pretty frequently, even in sentencing, because I knew that the government was going to get up. They didn't prepare for it, and they were going to get up and just reiterate the direct, which was gonna do no harm to my case.
Start at the start.
Right.
Yep.
And so what that comes from is I don't think a lot of people think about the cross-examinations before trial. I prepare. I prepare my cross-examinations. I go through, okay, what direct would I ask if I was calling this witness? Prepare the cross-examination beforehand, and I know what I want to get out. And I keep it concise to that. Because a lot of times if you make it too long, ultimately you're going to lose the point you're trying to make. The members are going to lose that. So you keep it short, you get out the points that you want, you keep it tight, and you don't reiterate the direct. Those are the biggest things, tips I can have for cross-examination.
Closing argument.
Closing argument is the best part of trial. Sir,
It seems to be a popular opinion.
Yes, sir. I imagine most litigators would tell you that closing argument is probably their favorite part of trial. It certainly is mine.
Why?
Because that's really where I get to get up and sell my position to either the military judge or the panel members. That is where it is my ship at that point, and I am pulling everything together. And all the work that I've done in preparation before trial, the witness interviews, the evidence review, knowing the rules, getting the evidence out there before trial is all leading up to that moment. It's that moment before I hand it over to the finder of fact to make their findings that ultimately is what this case, certainly in our minds at least, revolves around. Now, I think we know from studies it's not as important as we think it is, but we still think that. It will destroy our egos if we don't.
That's true.
And it's really, that again, that culminating moment of all the work you've done that you get to put into that, and that's what, to me, is the most exciting aspect of a trial.
Okay, great. And that's just sort of generally sentencing. I mean, what are you seeing folks doing or not doing on sentencing that catches your eye?
Yes, sir. The biggest thing is that there's not a lot done on sentencing, particularly in litigated cases. We put so much work into the findings, and we got our foot on the gas for findings. The minute the members come back with guilty, it's a sigh of relief, and then you'll see these 3-4 day findings cases, and then you'll see an hour sentencing case. We're not going out and actually doing the investigation for sentencing and understanding what evidence can come in sentencing. Certainly sentencing evidence is somewhat restricted for the government versus the defense, but we need to do a better job of actually putting out a sentencing case for the members so they understand why the sentence that we ultimately recommend is an appropriate sentence. Why that's so important is, if you look at findings instructions in the case, you're going to see 10, 15 pages of findings instructions. Sentencing, the judge basically tells them, you have from no punishment up to this max. Good luck. Have fun. So it's important that we actually do that investigation, consider sentencing beforehand, rather than just focusing on findings and then basically doing almost ad hoc sentencing after we get that verdict from the members. So the preparation beforehand and identifying sentencing evidence is the biggest thing that I think counsel need to do out there with you.
Okay. So I expect it's tough for you to give up closing argument to a young counsel.
Yes, sir.
What can a young counsel do to convince you that they are ready to take the next step and do something more substantive than maybe they have done in prior cases if they're working with you?
There's a couple of things that they can do. In the interest of full disclosure, does not happen very frequently in my career as a litigator. But what counsel can do is, first, it's not something that I'm going to go and offer them. So counsel, the first step is they have to ask for it. They have to want it. They have to come to me and say, I want to do closing argument. Okay, that's the first step. Second step is they have to be able to prove to me that they can do it. And that's through preparing a closing argument and actually giving it for me and giving it in a murder board. And I don't mean the night before trial, the night before closing. They need to have that prepared before trial, at least in a form that they can give it. It will change throughout, depending upon the evidence that comes in, but they have to be prepared to give it. They also have to have the blessing of their SJA at their base. I will always talk to the SJA if they want to do closing and find out, what do you think?
Yeah.
If the SJA says no, you can't do it, that's usually going to be a veto power there for them. But they have to have the desire to do it, have the ability to do it, and be able to demonstrate that ability. And even then, what I will say is there are some cases where what we're advocating for, what we're asking for, given the consequences that finding could have, where someone that's just out of JSOC with 3 ribbons, might be a lieutenant or a very junior captain, just doesn't necessarily have the credibility to stand in front of a military panel and make that argument. So even then, sometimes, and most times, I'm still probably going to give that closing argument. But those are the things that they have to do ultimately to demonstrate that they can.
Okay, great. It's great. So let's take a couple minutes to learn a little bit more
Yes,
about
sir.
Matt Neal. So let's see. Favorite sports team?
Favorite sports team, Pittsburgh Steelers and New York Yankees. Those are really equal
Okay.
for me. So.
Let's do favorite book or movie.
Favorite book or movie? I'll give you both. So the what will probably come unsurprisingly, movie, given my competitive nature, Gladiator, my favorite movie. As far as books, again, my nerdy aspect, I have an aerospace engineering degree, so my eyes are in the stars at all times. Anything by Carl Sagan. So Pale Blue Dot, Contact are both very good books.
All right. Talk about a couple of the bases that you really enjoy visiting.
Yes, sir. At Hickam, I love going to Hickam. I think that'll probably be a very popular answer. Most people love to go to
Easy
Hickam.
answer.
And then anything in Colorado. I don't care what part of Colorado it is. Colorado is my favorite state, and I love to go to any base there.
And Charleston.
And Charleston is, well, Charleston because of the SJA. Charleston's
Good answer. How about a place in the world you'd like to visit?
a place in the world I'd like to visit is a place I've actually already visited,
Oh.
Ireland. My favorite place in the entire world. I love that country.
Anything on your bucket list that you haven't done yet?
I haven't done mainland Europe, so I haven't done Italy, Germany, Greece, those types of areas that I'd love to do.
Okay. Probably an unfair question, but do you have a favorite case that you've worked on?
I do. A favorite case that I've worked on, United States versus Crown.
Yeah.
It was one of the more complex cases that I've done, a premeditated murder case that originally was capital, and then a pretrial agreement was approved in that case. And it, you know, sometimes we as attorneys, we lose sight of exactly why we're doing what we do. But in that case, one of my main responsibilities, it was a case down at Kadena, and I was the stateside STCs. I was the family liaison. I dealt with them most. And getting close with that family, and getting to know Curtis Eccleston, the young man who was murdered in that case, just gave me a new perspective. And it still touches me to this day. I'm still in communication with the family. Every time I go up to DC, I meet with the family for lunch, and we still communicate very frequently, and that case really sticks with me. And just the challenging aspects of it, both from the emotional aspect and then the legal aspect of it. So that be the case I'd have to identify.
Okay, great. So easy one to end. Let's see if you get this right. Besides your current boss, favorite boss you've ever worked for?
You can throw current boss in there if you want to, sir. Carl Thompson was my favorite boss I've ever worked for.
Good answer. All right, Matt, thanks for joining us today.
Yes,
A lot
sir.
of great tips for young trial counsel. I think they take it to heart that they'll be in your shoes someday.
Yes, sir.
All right, that's it. Thanks.